everybody that's here, welcome to the Social Media Club St. Louis event, Data Management, Privacy, and the Laws Affecting Your Organization. My name is Eric Kratom. I'm the president of Social Media Club St. Louis, and I'm the moderator or host or whatever you'd like to call me for today's discussion. Before I introduce our guest today, there's a little bit of housekeeping. We're going to be handling Q&A at the end of the session, so please use the Q&A function when you have a question. And I believe that the questions can be voted and commented on. So please check out the Q&A section to see what everyone feels are the most interesting questions. Otherwise, if you simply have something to say, I encourage you to use the chat function and make sure that you select the option for all attendees and not just the panelists to see your message so that we can hopefully have a lively discussion. Today, we're talking about the management of data, CRM data, digital monitoring data, and more. That includes, or as well as that, data privacy, data rights, and the laws around those things that impact you. The specific topics that we have planned for today are, number one, the stance on data and privacy taken by companies like Google and Apple. Number two, social listening and subject rights. And number three, and finally, what's been happening with state, local, and other data rights laws. But before we jump into all of that, let's get to our panelists. So we start today with Rand Fishkin, founder of Moz, inbound.org, and SparkToro. He's the author of, in my opinion, an amazing book, Lost and Founder, which I most definitely recommend you read if you have not yet. Rand is a well-regarded speaker, Italian food lover, and all-around kind human being. With that, I welcome Rand Fishkin to the show. Hi, Rand. How you doing?
Great, Eric. Thank you for having me.
Thank you very much. Also with us, we have Andy Schaul, head of digital platforms at Bayer Crop Science. Andy has worked with analysts and data scientists to collect and analyze social media and other non-traditional data for engagement, issues management, and more. Andy has a significant amount of experience on the legal side of these issues as it relates to subject rights. With that, I welcome Andy Schaul to the show. Hi, Andy. How you doing?
Hi, Eric. Hi, everyone. Great to be here. Excited for the discussion.
Thank you, Andy. And finally, we have joining us Professor David Carroll, Associate Professor of Media Design at the New School, and some of you might recognize him from the stunning documentary, The Great Hack. Professor Carroll has been an outspoken advocate for data rights for years and is someone that I recommend you should follow on Twitter if you do not already. With that, I welcome Professor David Carroll to the show. Hi, David. How you doing?
Doing great, Eric. Thanks for having me.
Thank you. Well, so let's start off with our topics, starting with major tech companies and their apparent stances on privacy, tracking, individual data. There are not too many clear lines, at least in my mind here. There are a lot of things wrapped together, whether you're a marketer, whether you're just an individual thinking about yourself. Apple's taken a strong and sometimes controversial stand on user privacy. Notably, in 2015 and 2016, Apple refused to unlock the iPhone of the San Bernardino shooter. And with iOS 14 and upcoming iOS 15, Apple has reportedly made it harder for their users to be tracked, which certainly has an impact on, for example, cookies and other aspects that impact marketers. At the same time, you have organizations like Google saying Chrome was going to begin blocking third-party cookies this year, only to then recently roll that back to not before 2023 when it will supposedly happen. Rand, whether you're looking at Apple or Google or other tech companies, what do you think about all of these statements about privacy and tracking and how they would impact people in communications and marketing?
Giant question.
Certainly.
Yeah, there's a ton wrapped in there. I think some of the most interesting and maybe useful, actionable things to think about for marketers, at least on the privacy side, is my belief is that the incentives are what govern the tech companies' policies, and unfortunately, for better or worse, depending on your preference for late-stage capitalist behavior, the values that those companies express are inconsistent and unimpactful long-term on their behaviors. So Facebook, for example, might say, we're protecting user privacy more. And they're not, right? It's just privacy theater. Apple might say, we're protecting user privacy. And what they really mean is we need to defend Apple's competitive advantage over the other major tech companies and make sure that we can continue to be a tech leader, and that tech doesn't become too dependent on user tracking, because that's sort of not our business, advertising dollars, et cetera. So I think that it pays to ask yourself, in any of these scenarios, what the primary incentive is for these companies. For Google, when they say something like, hey, we're going to eventually get rid of third-party cookies and yada yada, what they really mean is we're going to build a Google-centric universe for tracking and data collection, ensuring that the monopoly of Google strengthens and is undefeatable, right? If you look at something like the EU's GDPR, for example, right? This was, there was sort of all this like conspiracy theory. Well, did Google and Facebook really influence the lobbying behind the creation of GDPR and all these EU privacy laws? And then, finally you sort of saw, I think it was a Vice piece from a few months ago where they showed like the cookie trail of crumbs leading back to Google and Facebook in particular, essentially funding most of the research and the professors behind the efforts. And this was GDPR is sort of just a godsend for Google and Facebook. It ensures that essentially no European created company will ever compete with the big American tech companies. And I don't know, that's a weird thing to put into law. Like, nope, we give up. We don't ever want to. So that's a long answer, but I think that on any of those questions, and probably for the majority of this discussion, anytime you look at why are they doing this, you can see the incentives and trace that back.
So, I mean, there's a lot of questions that come to mind for me. One is, sort of like, I have a lot of questions around, so how do some of these individual decisions or statements impact, whether it's your company like SparkToro or somebody who's going to use this data, but maybe at a higher level or gosh, I don't know. I mean, I know, David, you of course have been very outspoken about some of these companies, and I believe that you have some strong opinions about legislation and so on. So I'm curious, like what Rand was saying, if you have just your thoughts on this.
I can certainly sympathize with the perception that regulation helps incumbents. That's a broad palette that's applied in many cases, but it's important to recognize that the reason the GDPR exists is because the EU Charter enshrines data protection as a fundamental human right. It's the equivalent, perhaps, of it being in the US Constitution. So the GDPR is just the outcome of more than 20 years of individual lawmaking in member states and jurisprudence and regulatory activity, just sort of standardizing it, updating it for the whole EU, and that in turn creating its so-called extraterritorial effects, which is what gets people outside of the EU interested. And indeed, the extraterritorial effects of this, the enforcement and legislation of this fundamental human right in the EU played out in the 2016 election, played out in the Cambridge Analytica scandal. But I wanted to jump back to a place where I really agree with Rand in terms of always analyzing statements from core incentives. And I like to phrase it kind of poetically, if you'll forgive the Roman Catholic metaphor, but the way that companies use privacy as a fig leaf for their original sins. Facebook is quite adept at this, sort of shamelessly shameful in its wearing of privacy as a metaphorical fig leaf in almost everything it does. Apple wears privacy as a fig leaf perhaps differently. And all these big companies can and do, and it's very strategic to define the word privacy. And I believe that that is the key advantage that incumbents have, is defining the language. What I like about European model is it creates incentives independent of individual business interests, but instead bases them on human rights or civil rights, as we might think in the US. And it does create rules of the road and sort of things to work through and around. And I think it provides a viable framework for responsible use of the data. And most importantly, changes the language from a talk about privacy to talk about data rights and data protection. And simply changing those words has a big effect on the conversation.
Is there, I don't know enough about this to say for sure, but I can certainly envision a scenario where, like you're saying, Rand, there's certain infrastructure, there's certain influence, whatever it is, where a bigger organization is simply better positioned to benefit for one reason or another when regulation goes into place. So like getting back to what you were saying, Rand, about Google and Facebook and so on, whether there was influence or not, or, and I'm not highly informed on this, I can envision the scenario where, exactly like you said, they're a startup or whatever may not be, like, they may be really hampered by some regulation but that Google or Facebook could skirt it, abuse it, could get a business advantage out of these things. And I see you put something in the chat. I appreciate that.
Yeah, sorry. So my mistake. It was not a Vice article, David. It was a New Statesman piece. But let's see. So, I have sort of two questions. So, David, I am not sure that I understood you correctly, but my sense was that you feel that GDPR is truly a law that does help protect users' data rights and is a good thing for EU citizens and sort of makes their lives, their digital lives better, or their online and offline lives better. And I am challenged to see that. I don't. I think that the intent is there. I absolutely agree with you that the EU's policy intent is good, and the execution strongly influenced by Google and Facebook, as you can see here, and Microsoft a little bit too, is beneficial to corporations, barely protects anyone from anything, and probably the human beings of the EU, in my opinion, would be generally better off without it. Or so let me put this a different way.
Well, then they'll have to
better
repeal
off
the
with a
charter
better
because it's
implementation
in the
of it.
charter. It's in the charter. They're obliged to have the GDPR. It's obligatory. So that was my main point, is it doesn't matter what we think about it, if it's good, bad, or whatever. It is another democracy's effort to uphold their core founding document. And in the US, we have a similar problem of companies influencing and writing laws. It's just, it's even more so. So I would disagree that the GDPR provides no meaningful protections. It certainly does. I could cite a clear example. Cambridge Analytica wanted to work in the EU elections as well as other places around the world, and wanted to work for far-right parties such as Front National in France and Alternative for Deutschland in Germany, and the equivalent party in the Netherlands.
Not a great thing for Jews.
The laws scared them away, that when they wanted to work for these political parties, the political parties said, for starters, You can't create political profiles of EU citizens without their consent and associated data rights. So the fundamental idea you want to do is not legal. And even you try to do it, you're just going to cause, a huge regulatory act, which was a great prediction, because when they did, they triggered the greatest fines the industry had ever seen and the greatest sort of turmoil. So in those moments, like, having protections scared away the bad guys. And that's the point of regulation and laws. It's not to punish good actors, it's to deter bad actors. And so there has to be something there. Now, there are many things about the GDPR that haven't even been enforced. And we could talk about EU's problem that Ireland is responsible for being the data cop for the entire economic bloc. So absolutely, there are enforcement issues. And in many ways, I could tell many stories about how the Cambridge Analytica was a stress test and the system failed it. But the enforcement of is more important than the compliance or the compliance to, because it's the enforcement of that has the deterrent effect, which is the purpose of having something in the first place.
Yeah. So my only slight input, I think you make some excellent points for certain. My only point on the Cambridge Analytica piece would be that Cambridge Analytica did not have users' opt-in agreement consent to collect and apply their data in the EU, but Facebook and Google do. And I think that's exactly why the laws are written the way they are, is because Facebook and Google are like, whoa, no, nobody else is allowed to get that. Only us. Only we are allowed to have consent from enough people to build enough profiles to sell the ads, to have the influence. And granted, far-right political parties don't make them enough money that they care a ton about, that particular niche. And so thankfully, the incentive for Facebook and Google is to avoid those problems and to monetize in other ways. But I guess I would say, I don't feel like EU citizens' privacy is protected. It is just protected from anyone who's not the big American tech monopolies. And to a certain extent, probably soon, China as well with TikTok.
Interesting. Well, so there are so many things that we can continue on, but this actually,
and Andrew has been so patient.
That's the thing. So
waiting for us to.
I think this bridges pretty well into a topic that Andy, you can probably speak well to, but then we can. It just merges all of this really well together. So and the topic in my mind is subject rights. So over 20 years ago, Scott McNealy, who co-founded Sun Microsystems and was the CEO at one point, he said, "You have zero privacy anyway, get over it." Google's Eric Schmidt famously said, "If you have something that you don't want anyone to know, maybe you shouldn't be doing it in the first place." And reportedly, Mark Zuckerberg of Facebook does not believe in privacy. And, to me, this sounds scary in certain contexts. But at the same time, social listening has played a major role in thwarting terrorist attacks and child predators, to name just a few examples, in addition, of course, to informing businesses about their audiences, their competitors, and so on. So, Andy, as somebody who uses social listening, who uses data from some of these big platforms, maybe not all of them that we've referenced, but you use it in such a way to inform crucial decisions for a big business. What do you think about, not just subject rights, but what you've heard so far?
Yeah, another really big question, and maybe a remark on the last conversation, is the complexity that we just saw in this conversation just now is part of the challenge for any company, small or big, who is not one of the tech companies. So, at Bayer, we're a global major corporation. We operate in all of these markets. And we, with our great attorneys, one of which I am not, and all of our data privacy colleagues and data management colleagues have to struggle with these very questions and how we behave and how we put practices in place, to David's point, not just for compliance reasons, but to make sure that we are able to continue to provide value to our customers, respect the rights that citizens around the world do have, and generally be more transparent and more thoughtful with what we do with the data that we're able to access. So it's super interesting, and I think all of that complexity has been something that I've wrestled with here at Bayer, and I can tell you the complexity mixed with the inconsistencies around the world with how these laws are coming into place and how they're enforced or not has created a even more complex environment in a large corporation. But let me step back and cover maybe social listening a little bit first. So, this is an area that has been of high interest for a long time. Any major brand, small or big, is likely doing social listening to understand what their customers or potential customers are saying about them, about their products, about their competitors. Also, it's a place where people express other kinds of opinions and points of view on many areas where companies may have interest, whether that's a product, a commitment they have to sustainability, for example, or to many other things. So super, super high interest. There's a huge marketplace of companies providing analytics and data access and insights on top of the kind of data we've talked about so far. So Twitter data, Facebook data, TikTok data, all these things, and not to mention all the other data out there on the web. And there's this high reliance on this data in some of these environments as well. So how do we build campaigns? How do we engage? How do we communicate? And how do we measure the impact and value of all that work? All of this is happening with social listening, among other inputs as well. So, and it's becoming increasingly complex. I don't need to hit that point. We talked about GDPR a lot, but we have LGPD in Brazil, we have CCPA in California, we have them popping up in every country and state around the world. And so it's getting harder. Not that because it's getting harder, it's a bad thing, it's just getting harder. So maybe let me step back, and I think David will hit this maybe more precisely than me, but when we talk about data subject rights, what are we really talking about? And especially in the context of social listening, I think it's helpful to be a little more specific here. And again, these are my general reflections. We're talking about a data subject's rights to know really who's doing what with their personal information. The right to see what personal information a person or company might be looking at for them. The right to change or amend their own personal data in other places. The right to request it to be deleted or not processed in the future. And David and I did not exchange notes before this, but I had on here, in some markets, it being a general basic human right. And so these are the kinds of things we mean when we talk about data subject rights. And these are, in my experience, the most common ones that come up in the arena of social listening. So from my personal perspective, I mean, these rights offer individuals greater access and control over their data. It demands greater transparency of organizations, including my organization, Bayer. It offers clear protection of certain kinds of data, so sensitive data like religion, political opinions, and health. Not saying that the implementation is exactly achieving that protection, but it aspires to do that. And I think it does, from a company's perspective, result in a more, what I'll say, focused utilization of resources. So maybe 10 years ago, when these laws didn't exist, or 15 years ago, you could sort of, if you had data, you could do what you wanted with it, and that was fine. Now, with things influenced by GDPR, you have to think about the lawfulness of your activity. You have to think about how you're going to manage that data, how you're going to delete that data at some point, how you're going to minimize the data you actually collect. And so it forces this conversation internally in a company like ours to say, do we really need that? Why do we need that? How do we document that? How do we make sure we're prepared to achieve the data subject rights that are not just required, but that we aspire to as an organization? All of that said, I think it's still very inconsistent and blurry. within any given market or law and across markets, which then leads to basic misunderstandings, at least in the realm of social listening. So I can tell you, well, I can't tell you how many times I've answered this question, but someone will come to me and say, well, somebody tweeted it, it's not personal information. Well, that's not the case. It is that person's personal information, even though they put it out on a public platform. And in reverse, just because something is personal information doesn't mean you can't process it. You just have to meet other requirements at the same time. So there's these basic misunderstandings that in a large organization that has many people doing communications, marketing, issues management, competitor insights, all these things, there's a knowledge that needs to be built up. And then when you start to combine these different kind of moving pieces, the differing interpretations of these laws, the different applications of them, the different enforcement mechanisms, you end up with, at times, an unequal playing field, which I think does connect back to the previous conversation. So, for example, we at Bayer have to interpret these laws a certain way and make certain decisions, but that does not mean that a competitor or someone in another industry will interpret them the same way. And so you could imagine a situation where one company chooses to do something and another one doesn't, and that offers some competitive advantage that wasn't necessarily there otherwise, or doesn't necessarily need to be there. But this interpretation step has caused a difference there. So I've spoken for too long, but it's super complex, and I'd love to hear thoughts from the rest of the panel and take it from there.
Well, yeah, as we've said, there's so many threads to pull on here. I'm wondering, so Rand, Andy, talked about a number of things as it relates to the data that you're collecting, the data that you're keeping, people getting access to that data, and so as much as you can say or not, like with SparkToro, from what I understand, you collect a bunch of data, right, about who is where and things about them, but then you're not surfacing any of that data, like PII type stuff, which for anybody that's here, if you haven't used SparkToro, it is really awesome. It is. It's a spectacular tool. You should definitely be using it if you're doing audience research, outreach, and so on. But anyway, that aside, Rand, I mean, you collect data on individuals, but then you have to deal with some of these issues, right?
Sure. Yeah. I mean, the big thing for us is it's sort of twofold. One is we have to make sure that we only collect data on publicly available profiles, on stuff that is, well, this is somewhat made easy for us by the fact that the platforms make it hard to crawl anything that's not public, but essentially SparkToro works like Google, right? So if Google can see something and crawl it and index it and surface it in search results, so can we. What we don't do that Google does, obviously, is, if you search for, Professor David Carroll, you can find his profile, right, through Google and click on all the social media links. David, I don't know exactly where you're active, but I assume somewhere, some places.
Yeah. Of course.
Yeah, maybe, maybe we'll get into a nice discussion on LinkedIn or something, or Twitter or Facebook, or maybe, David probably has a sexy Instagram feed. Look at that.
I used to. And then I had to delete it when I began my Facebook boycott. So I'm mostly on Twitter, basically. Yes.
Got it. So now you're a TikTok dancer. And in all of these cases, right, SparkToro basically crawls and indexes these, but then anonymizes and aggregates them. So you would never be able to see sort of like hey, show me the behavior and attributes and demographics of, David or Andy or yourself, Eric. But you can say, hey, show me the behavior and attributes of people who talk about digital privacy, right? And if someone's talked about digital privacy a bunch in their social feeds and their social feeds are public and we can crawl them, then we'll aggregate and anonymize those and index them and say, okay, well, we have, whatever, 50 or 150 or more. I think 150 is sort of our limit of profiles about this behavior. And so we'll show you the sort of, aggregated statistics, demographics, what they follow, what they tend to engage with, podcasts they tend to listen to, YouTube channels they subscribe to, et cetera. And all of that data is publicly crawlable. So essentially, we're really just sort of a time-saving tool, right? Lots of marketers do this already, but they do it manually. They go visit everyone's profile, and then they, whatever, download it or ask their developers to build a little, Python script to go grab all this stuff. And we were like, oh my God, this is horrible. Let's just build this for everybody. That process is really challenging. So yes, we have to, obviously had to work with some EU lawyers and some California lawyers and our own attorneys to basically figure out like what's legal, what are we allowed to collect, what are we allowed to surface, and that changes. We're right now, just FYI, not very active in Europe. So our profiles are English language only, US, UK, Canada, Australia, New Zealand, a little bit of South Africa. We unintentionally get some German and Italian and Swiss and French profiles, but they are English speaking profiles usually.
Go for it, David.
Anglophilic.
Currently,
yes.
A limitation of ours,
but the description of the cohorts of interests as a mechanism to sort of to conduct surveillance on data in a responsible manner, that there are ways to do these things responsibly. It does take extra thought and work, and the easy way is often the scary way. And I think that was what the big impetus for me personally that activated a sense of urgency is when I was a tech entrepreneur and building applications. And when you're sort of on the other side of the screen, you can find how the default settings just push you towards abusive practices. And it takes you a real conscientiousness to design systems otherwise. And indeed, like, spend the money on the lawyers who tell you things you don't want to hear. But they're doing it to represent the best interests. So it is a difficult process that is new, and the variances between the US and the EU and other models becomes a big part of the misunderstanding and the blurriness and the challenge to navigate it, even down to the most simple idea of the sort of philosophical idea. And again, not a lawyer, just sort of an armchair legal hobbyist. But what I've observed is that the US legal framework is about sort of castle doctrine, that your home is your castle and what happens in your home is our sort of national cultural definition of privacy. And then once you go out in the street, it's finders keepers, losers weepers, is sort of the rough way of thinking about it. Where across the pond, as I said before, the EU Charter enshrines fundamental rights. So any information attached to someone's identity kind of belongs to them, even if it's floating out in space, even if it's traveling the atmosphere of Earth. So this disparate philosophy, I think, causes a lot of the tension between the two models, and is one of the main things that industry, medium, small, startup, huge, monopoly, has to work out. It would be better, I think, if the world adopted the standard that is rights-based rather than castle doctrine, because if everyone adopted that rights-based model, it would at least simplify it for organizations. And the subject access request is the way to exert individual power against an asymmetric system, a system where you have absolutely no visibility into. So It is a structure that you are a dot in. And how does that dot exert itself at all? And it does it through the subject access request. And by asking for your data, you challenge the organization to find it. I dare you to find all my data. And if they can't do it, is that responsible use? Probably not. So it forces companies to behave better internally to achieve that risk factor if someone's going to ask for all their data. What do we do? And it does all the things that Andy was referring to, like rethink data use internally towards responsibilities.
Yeah. Well, okay. So I think there's something we're going to come back to, but to just keep going on, like you were saying, rights-based Castle doctrine, and Andy, you referenced CCPA and a number of these other laws. So, David, in recent history, many of us had to adjust to GDPR, while some of us, we've also dealt with CAN-SPAM, Castle, and other data and communications laws. Not all of these are the same or work in the same space, but there's some, relation to some impact, or the people that they impact at the very least. Now we have California, Virginia, Colorado, and most recently Ohio playing in the space. So, David, I'm wondering, where do you see data rights legislation going? And we've talked about it a little bit already, but where do you see it going in the future? What are you concerned about? What's good right now? All of that.
Sure, thank you. So the CCPA passed in many ways as influence from the Cambridge Analytica scandal. According to people who were in the room where it happened in Sacramento, anytime the big tech lobby would protest, you just had to utter the words Cambridge Analytica. It was like kryptonite. So it was a kind of once in a lifetime cultural moment to push through something that could have never happened otherwise, especially in California. And as a result, it does have aspects that sort of seem a reactionary force to that scandal, and so aren't necessarily exactly like GDPR. And doing something more like GDPR, I think, would be better for just creating a business standard of international data trade, creating the adequacy issues that are needed at the top level of the economic stack. So, and then the process of, demanding disclosure reveals if it's even possible. And in the end, the regulator of Cambridge Analytica, the UK's Information Commissioner's Office, they did not succeed at giving me all my data. It was journalism that succeeded at that some guilty person leaked the database to a journalist outfit, and then they came to my house and gave me my full data profile that I had spent years and way too much money trying to pursue. And so we do still need journalism to hold regulators accountable who are trying to hold businesses accountable. Yeah. And so we can't rely on any one member of, or any one aspect of it. So right now we're in the stage where the California Attorney General may be enforcing the CCPA for the first time. And so the first violators may be identified. I am really interested to see a subject access request case coming out of this California Attorney General's office. And I'm really interested to see the boundaries and contours of disclosure.
Yeah.
And that was the big battle in Cambridge Analytica. I believe that will be the battle ongoing. It'll relate to algorithmic transparency and automated decision-making, rooting out algorithmic bias. It really is fundamental to the human rights issues of the 21st century. So it sort of begins as the enforcement in CCPA in the USA.
Yeah. I have two things I would like. I mean, a lot. Like we could talk the entire day. Fortunately, we have a little bit more time. But one thing, David, I'm really curious. Like, what what in this space concerns you, but then also getting back to some of the stuff that Andy, you said, we can go, whoever goes first doesn't matter to me, wherever it makes most sense. I'm also really curious, Andy, as somebody who deals with these laws a lot, what's the most confusing? It's two questions, two different people. You can duke it out however you like.
I mean, maybe starting with confusing will maybe lead into what concerns David for the future. But I mean, I would say this to anyone internally as well. I have spent more of my personal working time talking about and advising on and learning about data privacy, data rights things over the last maybe 3 years than I ever anticipated. And I don't think that's a bad thing. I think that's a reality of where we are. And it's, you know, at first I was in that sort of phase of frustration where I was like, I could be doing other things with my time. You know, this is frustrating. It's going to change. There's going to be CCPA 2.0, and then I'm going to have to think about this differently. And that's just the reality. So I think accepting that is maybe part of the biggest challenges, and not just any individual, but like an organization wrapping their head around that, providing the resources and guidance they need for their people to be able to continue to do what they need to do and change what they need to change. I think that is the hardest part in this environment where it's changing. And then to David's point about, we have, I don't know exactly how you phrased it, but we might have CCPA in California, a different one in Ohio, a different one in Virginia. Well, companies are going to choose one standard at some point, whether it's GDPR or something like that, and just say, this is our policy. And it may or may not line up with what they need to do in the future. And so the pace of change is very fast right now, and large organizations at least will struggle to shift quickly and move the tanker. I can imagine the Suez Canal style situation where the boat gets stuck the wrong way for some period of time. And there's a lot more, but I'll leave it at that for now.
Yeah, thank you, Andy. I'm worried about the Suez Canal situation too. So the so-called patchwork of not necessarily complementary laws at the state level is the thing that I'm worried about, even though I'm so happy to see it happening, because just as we saw a ballot measure, a referendum in California spark the creation of the CCPA. So like the ballot CCPA was stronger than GDPR. They watered it down in Sacramento. The competition at the state level is sort of federalism at work, for better or for worse, in sort of developing a winning model, because unfortunately, you know, the Congress is not going to just copy the GDPR, even though that would actually be really convenient. So they have to rewrite their own. And so I'm worried that it won't happen within the window of opportunity, that there's a very short window where you could see Congress with a Democratic majority passing a national data protection or data rights law that was resolved state differences and created adequacy with the EU and other nations, and actually created a situation that businesses should want, which is clear standards that are not different and toward standardization and simplicity, and let the EU's human rights model be our guide, because maybe someday there could be a constitutional amendment enshrining data rights. And, you know, unfortunately, I think that's what it would take, because it is so like embedded deepest in the founding documents. That's what gives it the strength it ultimately needs in the law of court.
I think I would jump in and add to your point about, you know, companies want that in the future, this non-patchwork standard. I think that's absolutely true. And I think whether good or not, we're going to see, my prediction would be that we'll see massive amounts of litigation at the state level that will then get rolled up into a Supreme Court case, and it'll raise it to and it'll be a messy, very expensive, slow moving thing. So all of that to say, I think your point about the window of opportunity in whatever path that is, I think is a short one. And if not, and we see this on many other non-related laws in the US, and I think in a similar but different way with member states in the EU as well. So absolutely agree.
Rand, sort of following some of this, obviously you have some experience with collecting a lot of data. You have some experience with a decent sized organization. And now you're running a smaller organization, but fortunately you have your experience with you. I'm curious if you can you imagine a future where there are smaller organizations who maybe don't have as good of lawyers or don't have as good of knowledge, who are running afoul of these laws, and they get sacrificed while bigger organizations don't? I don't know. Where do you see some of this going for big organizations, small organizations? Are there disincentives for small organizations to collect data or use data?
Yeah, absolutely. Right. I mean, right now, if it were not for the fact that Casey and I, my co-founder, and I, and SparkToro is only 3 people, it's the 2 of us and Amanda. If we had not been able to raise a significant amount of funding, we raised 1.3 million. It was not a venture round like private round, but if we hadn't been able to do that and sort of have a 18-month stretch to figure out a lot of these issues, both on the technology side and on the legal and data presentation, and Casey had to build probably his least favorite thing to build was like the opt-out mechanism where you can remove your anonymized data from SparkToro, which means that frustratingly we have to actually know which data comes from which account or whatnot, which is data we don't really want to hold on to. Like, we would strongly prefer to not have that information, but we have to, because someone who's in the EU has to be able to request to opt out of it. And so for EU citizens, we actually collect, sort of more data, or we append and hold on to more data than we do for citizens of other countries. Right? So blah, 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 blah. Like, this is just one of many things. But if we had not been able to do that, have that long time frame, raise a significant amount of money, no way. So, if you're talking about, tiny startup, 2 folks in their, whatever, at their desks, like trying to hack away, you've really removed that. I worry that, if there were comprehensive, privacy and data collection laws, 20 years ago or something, you'd never have Google.
Right.
Maybe that's a good thing, right? Maybe, but I don't think you'd have search engines, right? There would be no way to find information, because you'd have all these laws around like, whoa, are you allowed to collect data about what's on Bayer's website and then store that and then make it indexable? I think a lot of the innovation that happens on the web is from the openness of those systems and the default public nature of it, and the fact that for a long time it went largely free from regulation. So you've got lots of things. The thing that frustrates me the most is the unevenness of the playing field, right? If you want to say like, hey, no one's allowed to collect this data, no one's allowed to use it, no one's allowed to abuse it, that has to mean no one. That can't mean everyone who's not a multi-billion-dollar tech company already. And that's not what it means today, right? What it means today is, hey, the EU, you will never be able to build a company to rival Facebook, Google, Microsoft, WhatsApp, and we're enshrining that into law. That's a strange thing to do, in my opinion. I think, granted, when I go to Italy and I'm like, oh man, all my wife's relatives work like 20, 30 hours a week and like get a lot of coffees and have 2-hour lunches. I'm sort of, well, maybe capitalism isn't actually that important and I should rethink my priorities. So maybe it's fine. Maybe they're like, no, we don't care about this competing with Microsoft. He's okay. Great, fine.
Well, so, and as we've said, there's so many, it's such a big discussion. There are a lot of things that are tied in here. I do, in the interest of time, want to move to Q&A. I've received a couple of questions privately, but hopefully people, are folks that are attending, if you have questions, put them in the Q&A here so that we can all see them. But before we do go to Q&A, I want to give our speakers a chance to do some shameless promotion if they have it. And so first up, we have Rand. Rand, where can people find you? What do you have to promote? What do you want people to know?
Oh man, I hate self-promoting. I mean, obviously folks can go to SparkToro and run some free searches. We have like a forever free account, but I do have a question when we get to questions. Like, I'm really curious if you know, David and Andrew could snap their fingers and change something in the existing laws, what would that be?
Awesome. Okay, so that'll be our first question. Obviously you mentioned a few things, but for the folks that are here, if you haven't, I'll do it a little bit for you, Rand. If you haven't read Lost and Founder, it is really good. So I definitely recommend that. I listened to the audiobook. I can't remember. Rand, did you read the audiobook? Okay, I thought so.
Yeah, it's my voice. Yeah. Had to sit there
and,
in a quiet room while a producer in New York was like, take that line again.
Nice.
A little slower.
Well done. I listened to most of my stuff double speed, and it worked out perfectly. I made a lot of notes as I was listening. And also, as I said, SparkToro is a really great tool. I recommend it to a lot of people, whether you're, you know, like if you have a client that you want to get booked on podcasts, for example, or you're doing content marketing and you want to figure out where can you get stuff placed or who is working in a similar space or whatever. SparkToro is a great tool. And Rand, you've created a lot of videos that are really helpful about how to use the tool. So as I said, you mentioned a couple of things, but just for the folks that are out there, I definitely would recommend check out the book and SparkToro. Next up we have Andy Schaul. So Andy, where can people find you if you want them to find you after this discussion? Sure. That is, what do you have to promote, and what do you want people to know?
Yeah, you can find me on LinkedIn or Twitter or Instagram or other places. So feel free to reach out on this topic or others. Happy to connect. I don't have a ton to plug. The only thing is that we have, for anyone in the St. Louis area who might be joining from the local group, we do have a position open to join one of our insights teams and work with some of this kind of data and help us discuss and solve some of these problems internally here. So if that sounds interesting to you, please find me on LinkedIn or anywhere else and let me know. I'm happy to make some connections and give you some more information on that. So I'll leave it there.
Awesome. And I don't know if you have it handy, but if you do have a link handy to a job posting or whatever, either put it in the chat, or if you get to it later, give it to me and I'll try to make sure to get that out to everyone. So next up we have Professor David Carroll. David, where can people find you? What do you have to promote? What do you want people to know?
Sure, thank you. Well, I'll leave the Netflix recommendation algorithm to promote the documentary, The Great Hack, to you, should you be the right target according to the algorithm to watch it. But you can supersede the algorithm and find it yourself if you haven't already. If you've seen the movie, I think there's a quote from the film that resonates with the sort of mood of the conversation. And it's by one of the Cambridge Analytica executives who said, without any hint of irony, there was always going to be a Cambridge Analytica. It just sucks for me that it was Cambridge Analytica. So if you haven't seen the movie, maybe that quote will get you to go. But rather than promoting anything else, I want to promote my students. I'm going to drop a link in the chat of a digital zine that was published out of a course that I taught this past spring. You can see the insights around these issues from the students in our program. And of course, if you're looking to hire, don't let me stop you. So that's the digital zine on a course I teach called Dark Data that covers a lot of these issues that we spoke about today for
Awesome.
Students that go on to work at these companies, big, medium, and small. Thank you.
Thank you. And before we get to Q&A, I'm Eric Pridham. I'm the president of Social Media Club St. Louis. I'm also the head of digital strategy at a really amazing and unique organization called Big Wide Sky. We are also hiring for a digital analytics pro at the moment. So please find me or go to bigwidesky.com. The job's posted on LinkedIn. If I get to it, I'll drop a link in the chat. I encourage you, anybody who's here, to join Social Media Club by visiting socialmediaclub.org and smcstl.com, which is Social Media Club St. Louis, smcstl.com. We have free and paid events and all of that online and in person. Well, in person when it's reasonable, of course. Next month, we're planning another online event along these lines called Did Tracking Kill Creativity? We have a nonprofit focused event on tap for the coming months. And if you're local to St. Louis and interested, we hope to have an in-person event as soon as logistics and the pandemic and precautions and all of that allow for it. So please check out Social Media Club, Social Media Club St. Louis, follow us and all of that. So let's get to the first question, which was about snapping your fingers. And I think, Rand, if I recall correctly, it's if you could change one thing, right, in the laws or the situation with the laws and so on. David, Andy, I guess, Andy, you're not on mute, so let's go to you first.
Yeah, and I do have to drop off to, unfortunately, head to the next one, so I'll leave it here. But I think for me, I don't know exactly what I want the change in a law or regulation to be. I just sort of yearn for the consistency, so that we're solving the same problems, and then we can work together, leverage the expertise, the insights, the inputs from all parties, and try to have a unified conversation about it. So that's what I would hope for. Maybe that's the inevitability in the long run, but I'd rather that be here now.
Well, thank you. And I know you have to run, and Rand, you have to run as well. David, if you can stay, then okay, perfect. Thank you both.
Thank you so much.
Thank you both.
Eric.
Yes.
And Andy and David, really a pleasure. Take care again.
Likewise.
Pleasure.
Bye.
So David, if you could snap your fingers,
Sure.
what would you change?
Well, since it's a kind of a magic question, I'll give a magic answer. I wish that the FTC had required Mark Zuckerberg to be deposed.
Mm-hmm.
I wish that he paid the $5 billion to avoid being deposed, in my opinion.
Yeah.
And I think it was a mistake to let him off the hook without having to answer questions under oath in that deposition. That would be essential. And I wish that the FTC was willing to use its ability to do algorithmic disgorgement, which would require companies to destroy not only data, but algorithms that came from ill-gotten data.
Yeah.
I think that's a more effective punishment than fines, which seem to just be the cost of doing business, especially when we're responding to the problem of just incumbents that are too massive. The only thing that's going to hurt them is destruction of software assets. That's it.
Yeah.
So I'd like to see them use that muscle where appropriate. And then I wish that, I wish that I could have snapped my fingers and the bad guys were punished appropriately regarding Cambridge Analytica. They really got away with it. Mm-hmm. And although it like shocked the system, they just scattered into the wind. So that troubles me.
Yeah.
So that would be my response to that.
Okay. Well, so, and this relates a little bit. Marie had a question in the Q&A about, well, it relates in my mind. She said, "Why not try to start lobbying for legislation that's similar to GDPR for the United States? Who do we contact? Our members of Congress?" But the relation in my mind is like, if you could change one thing with where we're going, one thing with what the public thinks about things, or the popular mainstream media conversation, what do we do about legislation right now? Who do we lobby, and where would you want it to go?
Sure. Yeah, a really common response that I get from people, especially those who have seen The Great Hack and reach out to me on Twitter and what do I do? And they think it's they think it's a technical answer, like,
right.
a setting I have to change or a plugin I have to install. But it's really, we have to do democracy. We do have to, engage with representatives because the industry is engaging with them otherwise. And the privacy activist community is very fragmented and independent. It's not unified under like one umbrella. So it really takes individual citizens calling up offices and just saying like, I care about this data privacy stuff. I want a national privacy law for my own business or for the safety of my kids' future, whatever you have. I think that the general message to lawmakers will translate into the committees and potentially on the voting floor in the absence of, deeper engagement. The other thing for people to do if they live in places where they have data rights subject requests is to exercise that right. So if you live in California, do CCPA requests. If you are EU citizen, do GDPR requests. Exercise the system to make sure it's working. And then in terms of who to talk to in the US, it has a lot to do with obviously who's your representative. But if you happen to live in the state of Washington, the representatives there are putting forth some interesting bills because the state of Washington, there's been interesting things going on at the state capitol. So try to find your own state's state house and federal level activity, and your representative or senator may be at play in one of these bills, and to express your support in the general idea of it will be important counterweight to the industry that will try to water it down because that's in their best interest.
So if I'm understanding what you're saying correctly, I think there's an aspect to this of, nowadays it's so easy to see a headline in your news feed or whatever it is, right? And say, oh yeah, I heard about that, but not actually read the article, for example. Or and it's very easy. People cynically, of course, will point out that that other people, of course, not me, feel like they're taking a stand on something by liking or retweeting or whatever, rather than, like you said, picking up the phone or, you could use any example you want, going out on the streets. But there, if you want a change or if something's important to you, then as an individual, you have to do something. And then hopefully not conversely, but similarly, at the very least, for organizations as well. If, nonprofit, for-profit, whatever, they're likely lobbying for what they as an entity want as well.
Yep. And I just hope that we could get business owners and organization leaders adapted to the idea that compliance isn't a chore, but it's an opportunity to adapt your business to the 21st century and the rights issues that we're already struggling with, and that pushing the standards up will lift us all up, and will create strong standards to create responsible businesses that are based on trust and mutual respect that will ultimately lead to good customer relations. So there's an argument within businesses and organizations to take the stance of someone like me, even though you might be like, everyone's complaining about this stuff, because if you can reorient your thinking, you could find new opportunities and white space that hasn't been fully developed yet. So it's a great opportunity from that perspective. You just have to adjust your thinking accordingly.
Well, and I think there are two relevant questions, one that came up in the Q&A relevant to what you were just saying, and one that came up in the chat. But I want to go back to something that John posted a little bit ago, which I'll just go ahead and read the whole thing. So most of our clients are US based and regional. When they ask about privacy, GDPR, cookie collection, et cetera, we typically tell them it's up to them and that it's not affecting them right now. We cite different resources to back this up. But in your opinion, do you see any issue with that? The ROI for us doing much regarding GDPR and privacy for our clients isn't really there, so we minimize it and move on. Thoughts? And then he says, for example, a manufacturer that serves the Southwest US just doesn't seem that it needs to be a concern for them right now. So what do you think about that?
Yeah, I mean, I'm not a lawyer, so wouldn't want to give flawed advice, but I can just say that the regulatory apparatus is struggling to enforce the law.
Yeah.
Even when it applies in the most dire of circumstances. So this is not easy.
Yeah.
And to assume that there are like massive resources to throw at little inconsequential companies is that's a fallacy too. When it comes to the FTC, it does try to set examples of bad actors. So don't be a bad actor, and you probably won't be a FTC enforcement case.
Right.
I mean, and if your business necessitates more than the bare minimum, then you have to be able to recognize that.
Yeah. Well, so mentioning the FTC, that reminds me a bit of, a little over 10 years ago, I worked a lot in social listening, did some relatively big data projects at the time for, Fortune 10 and all of that organizations. And around, 2010 or so, I think is when the FTC finally made some sort of declaration or whatever, that if you're being paid to talk about something on Twitter or whatever it is, you had to state, this was sponsored or use a paid hashtag or something of that nature. And basically nobody was doing it. And even nowadays, you don't see a lot of that, with having given a name to what we call influencers nowadays. I think you see sponsored and all that a bit more, but what you're making me think of is, gosh, it sure doesn't look like a lot of people have ever been punished, individuals have ever been punished for not saying that they were being paid to promote a product, for example. And so perhaps similarly, I don't know if it's a great comparison or not, but based on what you're saying, if you're a small-time organization, sure, or small organization, I should say, you may very well be afraid of the government clamping down on you. But I think you're saying it's highly unlikely, unless you're doing something really flagrant.
Yeah. I mean, yeah, exactly. This perception that there's like a legion of bureaucrats with huge budgets to get after every jaywalker. They're going for the big fish, and they're going to root out invasive species. That's what they're there for. That's what their main mandate is.
Awesome. Well, so I guess let's do one last question and then we'll wrap up. So Ashley said in the Q&A, what's the most shocking gap of knowledge the general public has about data privacy, or what's a way we are too trusting of big companies?
Well, I think the public, has no idea the amount of personal data that is exchanged in the data broker industry. And so seeing a window into that, I think would show people the sort of dossiers that exist about them. They would be shocked to see the aggregation and the way the data is appended and linked, and the cross-linking, cross-identification would really blow people's minds that it happens at grand scale and constantly. Yeah, well, I tell people this story from, I think it was 2010 or maybe 2011. A friend of mine worked with an organization that I'm trying not to name names here. They do a lot of digital displays, basically. So you're in the mall, let's say, and there's a digital display, or you're, the digital billboard or whatever it is. And back then, so over 10 years ago, they were working on some technology that fairly reliably would identify out of all the people passing,
all their different genders and roughly their ages, so that then they could pull, I guess, programmatically from an advertising database to show on this digital banner what would be apparently most effective to people, which, I mean, if it were a single instance, wouldn't be all that concerning. But if, in my mind, you go a couple more steps towards facial recognition or whatever, and then you have this ability to perpetually track, for example, someone's location. And I mean, yeah, you know, I don't want to sound like too tinfoil hat crazy here.
No,
but yeah.
you've described a scene of the Steven Spielberg sci-fi thriller Minority Report, where the Tom Cruise character is a fugitive through the mall, and Lexus and Amex ads are personalizing as he goes by, being tracked by a dragnet surveillance state. So marketers tend to want sci-fi dystopia if they don't have someone sort of tapping them on the shoulder being like, really? So the self-check helps, you know, like, are we building dystopia to save money on ads?
Yeah.
Because the important thing to remember about being an advertiser is the famous old saying, half the money I spend on advertising is wasted. I just don't know which half. I'm afraid to say still is true today in the year of our Lord 2021, that the technologies that claim to do this for you are somewhat snake oiled. So marketers are marketing to each other. And so we have to wonder, like, what are we sacrificing for an elusive benefit even? So, you know, that's why the human rights stance helps us all, like, make good business decisions that are good for society. And it may cost more money, but it's probably a necessary cost to pay. Yeah.
Well, I mean, from an individual perspective, that you can, I mean, some people are concerned and don't do anything. And then whether from an individual or a professional perspective, depending on if those are somehow divided in your mind, then there are perhaps different concerns. But it seems like one relatively consistent theme throughout our conversation is that there are substantial benefits to being aware of these laws and ensuring that no matter how they change, that and no matter what new innovations or whatever come up, that it is worth a marketer's time and organization's time to be aware of and stay in line with these things. You know, because in a small organization, maybe they don't get punished if they run afoul of a law or not, but there are major societal implications for how data is being collected, how it's going to be used, if not today, 10 years down the line, so on. So, well, I do want to make sure that we don't keep everybody for the maximum amount of time here, that everybody has at least a little bit of time back in their day. So I do want to wrap up. If anybody here has any questions or follow-up, please email Eric at bigwidesky.com and follow me, follow Professor David Carroll, Rand Fishkin of SparkToro, and Andy Schaul of Bear Crop Science in social media. You can also follow Social Media Club St. Louis or Social Media Club. Professor Carroll put his Twitter handle in the chat, so please follow him. Like I said, I recommend it. There's so many things we could have talked about, like the interesting stuff that went on with the NYU researchers recently. There's a lot, but we can't do everything all at once. We'll take another bite of the elephant next time if we get a chance. Thank you again 1,000 times over to Rand, Andy Schaul, and Professor David Carroll. And thank you to everybody that joined us today. I really appreciate it. And goodbye.
Thank you. Bye-bye.